All right, we're going to go ahead and get started. Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing tips to minimize conflict during co-parenting, and we are grateful that you were all able to attend. As a member of the Colorado community for over 25 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service we provide to our community as a resource during these crazy times. A few points of housekeeping before we get started. If for any reason you lose your connection to the webinar, please email me directly at Izzy, I-Z-Z-Y, at harrisfamilylaw.com, and I will help you rejoin. Also, please feel free to ask any questions using the Q&A option at the bottom of your Zoom screen. We'll try to answer all of them at the end of the webinar. Now, I would like to introduce our presenter today, Rich Harris. Rich is the managing partner of the Harris Law Firm and has been recognized by numerous legal organizations, including Best Lawyers in America in 2020, and has been a repeat selection to the Super Lawyers list for family law. He's also published many articles across a range of family law topics, as well as being the co-author of the Colorado Family Law Desk Book. Without further ado, I'll turn it over to you, Rich.
Well, thank you very much, Izzy, for that mighty kind introduction, and thanks to each and every one of you for joining us tonight. This is a really important topic, and I'm looking forward to discussing it. Before I plunge right in, however, a couple of additional points of housekeeping. First of all, we're broadcasting tonight from a couple of different remote locations, not our regular office digs. Like a lot of you folks, I suspect, we're still trying to navigate this hopefully post-pandemic world. So hopefully we'll proceed tonight without any glitches. But if in the background you hear any unexpected noises, be it kids or that sounds like some hammering or what have you, let me apologize. We'll just continue forward. Secondly, on a perhaps more important note, please know that the information I'm going to be talking about tonight should not be considered legal advice. Legal advice is simply beyond the scope of what I'm able to do in this setting. And we're going to hopefully provide as much concrete, practical information that's generalized for a broad audience. As Izzy indicated, I'm happy to try and field questions, but please know that my answers are going to be more in the broad context in terms of Colorado law and my experience as a family law attorney here in Colorado. So with that being said, let's move forward. For those of you who've had any interaction with myself or any of the lawyers at our firm, or perhaps you've been to our website, hopefully you know that a big point of importance for all of the folks at our firm is to attempt to resolve family law disputes with a minimum amount of conflict. The reason for this, we're going to get into more detail tonight. I suspect anybody on this call tonight understands why that's so important, but it certainly drives everything we do. Obviously, folks are in the family law courts for a reason. You're experiencing conflicts. We lawyers and judges are there to try and resolve them. And if you can't resolve them by way of compromise and agreement, of course, we litigate. But we'll talk about tonight some strategies to either minimize the chances of litigation or conflicted litigation, or if you're already in the midst of either litigation or simply a conflicted co-parenting relationship, some strategies you might use both to protect yourself and your kids and perhaps ratchet things down just a bit. In terms of how my remarks are going to be organized tonight, first, I'll talk about a little bit more on the why in terms of keeping the conflict down. Then we'll get into the meat of the presentation with respect to some of these tips and strategies. And finally, as we've mentioned, hopefully we'll have some time at the conclusion for some Q&A. So first, in terms of minimizing conflict, why do we say it's always best where possible? Where possible, that's a big caveat, obviously, but if you can find ways to ratchet down the conflict, there's going to be a lot of benefit. First of all, I can tell you without any hesitation that if you're able to settle your case and compromise without having to wait to get in front of a judge for a contested hearing, it's going to cost you a lot less time. For anybody that's in the family law system now, or perhaps in the recent past, you know that the system is incredibly overcrowded, overburdened, understaffed. Not a good situation for sure. And I will tell you that since the pandemic began, and even now as we're coming out of the pandemic, the dockets remain incredibly crowded. In fact, we're all navigating this whole post-pandemic world. There are announcements coming out from different districts almost daily about masking or not masking in the courts, hearings in person or hearings via video. What you're hearing in the news in terms of the controversies in schools, employment situations, etc. It's also, as you can imagine, playing out in the court system. So to make a long story not so long, the punchline is you need to be doing everything you can to avoid trying your case in front of a judge. Next, absolutely without hesitation, I can tell you after 28 or so years of experience in doing this stuff, that the folks who are able to minimize the conflict and settle their cases either fully or in part are under a lot less stress. It is an incredibly difficult thing, without question, just to deal with the fallout of your life changing in a dramatic way via a divorce or a breakup of a co-parenting relationship, etc. Clearly, those are one of the most stressful events that any one of us can experience in our adult lifetimes. But you add to that fighting over the important issues that come out of it, and it's an incredibly stressful, if not scary, if not confusing process, even with the best of legal counsel at your side. So less stress for sure if you're able to settle your case. A corollary to that, and this is oftentimes, of course, a cause of stress, litigation is expensive. There is no question about it. Legal fees are expensive compared to almost anything that we consumers spend our hard-earned money on. In a lot of situations, especially those with kids, we think it's very important to have good counsel, but lawyers, including our own, typically charge their time by the hour. And that means that the longer it takes to resolve your case, the more expensive it's going to be. And that can be an additional cause of stress and fear. And then finally, this is a really important one that I think a lot of people don't realize. The family law courts, or our statutes, I should say, inherently have a lot of discretion built in for the judges. What that means is, unlike other areas of law where judges have a really clear step-by-step order to decide things in a family law case, by contrast, judges have a lot of discretion or leeway or latitude, however you want to term it, to determine the orders in a case. child custody, division of property, the awarding of maintenance, even to some extent child support. There are things built into our statutes that give the judges a wide degree of discretion. So why is that important for this discussion? The reason is that when you have a contested case and you have to put it in front of a judge, you're essentially putting your fate in essentially a stranger's hands. Hopefully a very educated, well-qualified, caring stranger, hopefully, usually, but not always the case. But you don't have control. You're rolling the dice, and your window of outcomes is more broad than you might expect. I've been doing this long enough. I've seen all sorts of different results in cases, and I've been to seminars and I've had conversations with judges where you can present the same issues with the same details to 2 or 3 or more different judges and get a very different, well-reasoned, not appealable decision from each of them. So if you're able to resolve your dispute and perhaps not get everything you want, but come to some sort of agreement that is going to protect you and your kids and is going to be workable for you, at least you have closure. At least you're deciding your own outcome. Again, you might not be getting everything you want, but you're able to determine what it looks like. I will tell you that judges love settlements, as you can imagine. With dockets being as crowded as they are, judges literally have hundreds and hundreds of cases assigned to each of their courtrooms. Every time that we lawyers tell them we've settled the case, we can't hear it, but we suspect there's a little bit of happy dance that goes on in the judges' chambers. It's one less case they have to deal with. And so long as the agreement is not incredibly one-sided or outrageously and obviously unfair, judges are almost always going to approve your settlement. So that's what I mean by deciding your own outcome. When you settle and compromise, you're deciding the result of your case. So let's talk a little more then about an issue that's near and dear to my heart. And I will share with you that my care for and passion for kids and children's issues is the reason that I and most of the lawyers at the Harris Law Firm are in this field of law. So we think about this a lot. We care about this a lot. I'm a parent myself, as an aside. The fallout from litigious or contested divorce falls most heavily on kids. And of course, it's something that you want to avoid at great cost. Here are some things to think about. And some of this may or may not be obvious, but I will tell you, based not only on all of my experience in working with literally hundreds of families over the years, but also keeping up on the mental health literature, that the mental health risks to children in a highly litigious divorce are significant. And they're some of the worst dangers you can think of: depression, substance abuse, self-harm, all sorts of things, even worse. These things are real and they can be long-term, if not permanent. And the literature bears that out. Some of these risks you might not even think about. And they might not even show themselves in terms of the harm for years or even decades into the future. And we've seen this in some longitudinal studies of these kids after divorce. For example, challenges with their own future romantic relationships, symptoms of PTSD arising from traumatic situations during the breakup or the divorce. These things are real, they're there. I don't share them to scare anybody, and certainly not. Please know I'm not judging anybody as we're going to talk about it. I'm well aware that some of you are in contested situations that are not of your own making, without question. But it's more to the point of emphasizing the importance of doing whatever you can to lessen it even a little bit. Some people say, well, if the fallout from divorce is so awful, maybe I should never have divorced. Maybe I should have stayed in perhaps an unhealthy or worse relationship. The good news there, from what we understand, or more specifically, what the smarter experts than me understand, is that the trauma to kids, by and large, comes not from the mere fact of the divorce or the kid's parents' breakup per se. The trauma, especially the more significant trauma that we're talking about, is more driven by the amount of conflict before, during, and after the divorce. So the settlement of the disputes, regardless of where you are right now in your life or your current relationship, in an amicable way, should be a top priority for every single parent. Another thing to think about when we're looking out at a contested situation is how often, sometimes even unwittingly or inadvertently, kids are put directly in the middle. Now, some parents do it, if not deliberately, then at least recklessly. They're talking to their kids about the stress of a trial. They're talking to their kids about the fact that the ex isn't paying child support. They're having the kids negotiate or help negotiate visitation arrangements. These are inappropriate and harmful things to do. And not only does it harm children potentially over the long term, but it's going in many, many cases to also harm the parents' legal positions. And here's why. There's a few different reasons why, but this, in my mind, is the most important reason. Under Colorado law, judges are required to look at each parent's relationship with the other parent, but specifically how able each parent is to encourage the children's relationship with their ex or soon to be ex. Let me repeat that. Colorado judges are required to determine whether parents are encouraging their kids' relationships with the other parent. It is a specific factor in the best interests of the children statute. It's something every family law judge knows like the back of their hand, and every family law judge must abide by for fear of being overturned on appeal. Okay, so what this means in a nutshell is, look, judges don't expect you to be best friends with your ex or soon to be ex. Obviously, you're getting divorced or you are divorced for a reason. The point is that you need to be able to show a judge that despite your own differences with your co-parent, that you want and hope for your kids to have a loving and healthy and strong attachment with your ex. Except in very extreme situations where it's a really harmful situation. So people sometimes ask me, and maybe you're thinking this as I'm talking here. Well, Rich, what about the fact that my ex is this unhealthy, bad parent? So that's obviously the case quite often, unfortunately, for all the kids out there and all the exes dealing with those poor parents, and society in general, by the way. But you should be letting the court know, meaning the judge or any experts that are talking to you and making recommendations to the judge, that you hope and wish that your ex would heal and get better. Because if they were better and if they could get their act together, you'd like nothing more for them to have a great relationship with the kids, that you know it's important to your kids' emotional development. So that's how you would handle that. So let me then turn to some of the things that you can do, whether you're in a difficult situation or you fear you might be going into one. Number one, realize that when it comes to family law matters, there are alternatives to how the cases are processed. Okay. Generally, before I talk to you about the specifics, in general, think about the fact that when we say litigation, we mean filing, pleading, serving them, and then fighting every step of the way. Even after you file, in general, your mentality, your focus should be in looking for those areas of compromise, those areas for settlement, no matter what the other side is throwing at you. You should always try your very best to think about ways to compromise. Next, there are experts that you can hire and bring into the proceeding that, if they're qualified and they know what they're doing, they can often be helpful in reaching a settlement. Typically, we're talking about at least masters, if not PhD level psychological experts who will go in, interview the kids, the parents, other significant folks in their lives, do some testing, some analysis, depending on what you hire them for, and then they'll make recommendations to the parties and their lawyers and to the court. I bring this up because very often, if you can get a qualified expert, it's worth the additional expense, because it's my experience that when the recommendations come out from a good expert, your case is more likely to settle by compromise. There are other kinds of experts that you can bring in after you're divorced. And one of those is typically a lawyer who is empowered sort of as an arbitrator, a PCDM. It's one of these fancy shorthands for a decision maker or parenting coordinator, somebody who you and your ex agree to use to resolve future disputes before going back to court. Mediation, collaborative divorce. These are what we call alternative dispute resolution mechanisms. These are ways that you sit down with a third-party neutral who assists you in reaching a settlement. You, in most cases, will still need a lawyer because these folks can't give you legal advice, but a good mediator can make a huge difference. And we've seen so many cases that we thought were beyond redemption in terms of the amount of conflict, where a good mediator and some smart lawyers were able to ratchet things down and find ways to compromise. So, next thing to think of is your own mental outlook. What I mean by this is adjusting your expectations and your goals will not only help you have a lot less stress, but I think, and I feel pretty strongly about this, that with the right outlook, you're going to be more open to finding solutions because, well, let me get into some of these details and I'll explain this. The family law courts in Colorado, as well as most of our country, are not set up to pick winners and losers. It used to be way back when, even before my time in practice, where in a divorce, the filing party was the plaintiff. We had plaintiffs and defendants. We've gotten away from that language. Now we have petitioners and respondents. It's still technically a civil lawsuit, but we're not trying to pick a side. What we're trying to do is divide things up, protect people's finances, minimize the fallout from the breakup, and protect the children. All these factors, by the way, are enumerated in one of the statutes. Judges are not empowered or even allowed to decide who was right, who was wrong. It's a no-fault divorce state here in Colorado. That means that the reasons for the breakup are totally irrelevant to how the property is divided, and in most cases, to what happens to the kids with the child custody. It's just irrelevant. And we're not even allowed as lawyers to bring up fault in a divorce trial. Okay, so to the extent you're hoping to prove your case to show that your ex or soon to be ex was an idiot and a scoundrel, even if he or she really was, you can't be focused on that. With all due respect, you should not be focused on that. It's just going to lead to far more heartache and stress and ultimately disappointment. In a no-fault divorce state, we divide property equitably, which is a fancy word for fairly, reasonably, again, without regard to who did what and who was right, who was wrong. Okay? Child custody, best interests, not even who's the better person, for sure. It's who has the appropriate parenting abilities to best take care of this incredibly precious gift, your children. Negotiating. So I keep talking about trying to find settlement, trying to compromise, trying to minimize the conflict. How do you do that with somebody who has an opposite opinion on things and wants the opposite from what you want? There are a couple things to think about. In terms of negotiating, you should be thinking as dispassionately as you can. In other words, wherever possible, try and keep your own emotions at bay. Try to look at all the issues as best you can. And I realize easier said than done, but as best you can, like a business situation. Okay. What that means is if you can list all of the issues on a piece of paper, on a spreadsheet, whatever you want to use or your lawyer wants to use, you should be able to identify which of the issues are most important and which are least important. And here's the interesting thing when it comes to negotiation strategy. If you were to compare your list to your ex's list, in almost every single situation, the priorities are not going to be the same. You're going to value certain issues higher than he or she will, and vice versa. What does this mean? This means you should be looking for things that you can trade that are less important to you for things that are more important to you. Plus, you should be aware of and thinking about and anticipating which issues are most important to your ex or soon to be ex, or most emotionally laden in terms of the way your ex thinks about things. Okay, I'll give you an example. Let's say that you're trying to work out a visitation plan with your ex, and you have an agreement that says, one of these, I think, very poorly drafted agreements that says you're going to split all major holidays. You get into it, time goes by, you realize, what does that mean? What are major holidays? What does split mean? And all of a sudden you're fighting, right? So let's say in this situation that now you have to come up with a compromise, because come the holidays in December, every single year, you guys are fighting. So here's what to think about. Let's say you come from a family background where Christmas Mass is really special and really important, and maybe you always did that as a kid. Christmas dinner, maybe not so much. If the Christmas Eve Mass is most important, and you know your ex doesn't care about that so much, perhaps you trade that for the Christmas dinner, and maybe you even give up a little more in terms of an extra day or two in the break period. Same goes for property. You might be fighting over furniture. Maybe you want to give away all the used furniture in exchange for the one special piece of furniture that you want to have as your dining room table moving forward. Again, you're trading what's important to your ex and receiving what's more important for you. And oftentimes, if you're savvy with this and your lawyer is savvy with this, you can come up with unequal, in terms of value, divisions of assets. Next, keep in mind that if your negotiation is not going well, please try not to just give up. Don't walk out. All may not be lost. I can tell you that it is far better to reach agreements on some of the issues, even if you can't resolve everything. Don't throw out the baby with the bathwater. If you can't resolve everything, look to the things you can resolve. And as a suggestion, if you're negotiating directly, or you're helping direct your lawyer to negotiate, or you're in a mediation, start with the easier, less controversial issues, and then move on to the more difficult issues. If you start right out of the gate with, I'm never going to pay maintenance, no way, no how, I will never do it, and that's where the conversation starts, you might scuttle the whole process and walk away with nothing. So that would be a mistake. Okay. If you do reach an agreement, it is very important. Make sure it's signed and dated. And if it's anything related to your divorce or the issues post-divorce, like visitation, custody, child support, make sure you file it and get it approved by a judge. This is really important, folks. We have situations all the time where somebody comes to us and says, look, we had an agreement years ago and now she's breaching, and we call up the other side, and lo and behold, the other side denies the agreement ever existed, or they have a different interpretation of what was in the agreement. Get it signed, get it filed, get it approved by a judge. Okay. Here are some things to avoid. Doing the following things will almost always be a mistake tactically, and it will increase the conflict unnecessarily. So if you're disputing or even discussing a division of property, don't try and hide anything. Don't try and hide the assets, put them in a foreign bank account, move them offshore in any way, try and change title, try and pretend they don't exist. Don't hide the documentation. Don't withhold the information. Look, there are some people, I am sure, that do these things and get away with it. And that, as a professional, it kills me. I hate that. And I'm so sorry for the victims of people who do that kind of thing. But I will tell you, most of the time it does not work. And even if it does work at the initial time, once it's found out later, it hits people like a load of bricks, and it really hurts their position in any future hearing. Next, please be careful about who you talk to your private details about. This may seem obvious, but I can't tell you how often we see people saying, frankly, dumb things on social media. Maybe well-intentioned, but it just is almost always going to harm you. They're taken out of context. They can be used against you. They can harm your credibility. Folks, the same advice that if you're a parent, you're probably giving to your teens, if you're like us, almost every day. This goes for us as adults too when we're in trying situations. Keep the circle tight in terms of who you're sharing the details with. Okay. Same goes for talking to other people that are within your common community. Now, one of the things I recommend is make sure you have some trusted confidants, people you can completely share everything with, unload on, get honest feedback from. That's all good, if not important. But the last thing you want to do is take people who are maybe joint friends, family members, gosh forbid, co-workers, and start talking badly about your ex. It almost always is going to backfire. It's almost always going to increase the conflict. Next, when we talk about your outlook, a little more on that. The big picture here. The divorce you're going through, or even the post-divorce fight you're going through, might be the scariest, most awful thing you've ever experienced. Realize, however, there is going to be closure. I promise. There's going to be light on the other side. Don't do things in the short term. Think about what you need to do to get through it by way of compromising even bigger things in order to be able to protect your money, protect your stress and your sanity, and move on, protecting your kids as well. Okay. Listen to your advisors. By advisors, I mean not only the professionals that are around you, but anybody that you've taken into your confidence. If they're telling you, look, you're off base on this one, or you're hanging on too much on this one, trust the people that you have entrusted. Listen to them. Their duty is to be this more objective feedback person for you, and they can be very helpful. Next, if you're feeling emotional, let others, especially the professionals, present your positions. Don't ever go to a negotiation or mediation, or gosh forbid, send an email or write a letter in the midst of an angry or a confused state of mind. If you need to, take a break, but where possible, let the professionals speak on your behalf. Make sure they understand what your position is, of course, but let them present for you. They can do so dispassionately. Don't let your emotions, your short-term emotions, however strong and legitimate and real, I'm sure they are at any point, don't let them dictate your decisions in your all-important family law case. Take care of yourself. I can't emphasize this enough, and it's often overlooked. You will almost definitely be more open and available to compromise, and almost definitely be able to see a settlement and to get a better outcome if you are as healthy as you possibly can be. It's not going to be perfect. You're going to lose sleep. You're going to have some tearful nights and maybe even days. You're going to feel down, maybe horribly depressed. You're going to be missing meals. You're going to be freaked out. I get all that. I don't get it. I'm not living in it, but we can empathize with what people are living with. But you still need to do the best you can to take care of yourself within reason. Diet, exercise, meditation, yoga, whatever helps you stay healthy is what you should be thinking about. And do the best you can. Have a little grace for yourself. If you fall back, that's okay. Move on. Keep trying. Everything you do to stay strong or regain some strength is going to make you a more present and available and strong person to get through this process. Get some mental health help. Please don't fall into any notion that it should be a stigma or a source of shame. Absolutely not. It can be very helpful. It's often very helpful for you, for your kids. Please consider getting a good therapist or a coach if you don't already have one. By the way, on our website, we have links and lists to all sorts of professionals that can be very helpful to you. Keep your friendships up. And by friendships, let me qualify this. A lot of people go to the person that's in their ear that's also going through a divorce, or also has a chip on their shoulder, or also went through the ringer with their own ex. Those can be good friends, but they also can be not so hot friends in this situation. You need perspective. You need fun. You need release. What I'm talking about is trying to maintain the kinds of comforting and fun and connective relationships, friendships that you had before you felt like the world was falling apart. These people can be so helpful to you. So, how do you deal with an angry or difficult ex, right? So you have all these strategies, you've got these under your belt, but your ex is really off the rocker. And don't worry, I have a crazy picture of a crazy male person too. I don't want to be sexist here, because certainly this cuts across the board here. What do you do if somebody's attacking you? If somebody is playing games, always take the high road. By the way, this is the same coaching advice I give to our younger lawyers because you've seen it, I'm sure you've heard about it. Other lawyers can be boneheads, to be honest. They're doing all these underhanded things. You take the high road. You don't play in the mud with them. You don't get into the minimal details. If they have a 10-point diatribe, ignore the smaller things. Respond only to what you think is important and to which you think a response is owed. avoid any kind of conflict during a parenting time transfer. Those are awful and terrible, and get yourself out of the situation if there's a confrontation at an exchange. Document everything and bring it to the judge if you need to. At the end of the day, you can't reach compromises with a lot of people at all. And at some point, if it's brain damage, you have the right, you absolutely should, and you'd have my blessing and any other professional's blessing to shut it down and say, look, I've tried. I'm just going to need to see you in court. And that's what you've got to do. Okay. What about the ex who is dangerous? Okay. There is no real method, not without a real sophisticated mental health expert involved in the case, to really compromise with somebody who has a personality deficit. There's all sorts of them, and I see time is short. I'm not going to go into them. But if you're dealing with somebody who's bipolar or severely a narcissist, has a whole host of personality disorders that are out there, you probably need to not only be aware of it, but limit the conversation and get professional help. For sure, if there's violence, stay away. No compromise, no conversation, not without your safety being paramount. I would always say this, but I say it even more forcefully today. We're witnessing an epidemic of domestic violence. And the last decade or so, things are worse over the last year and a half. All the conditions for abusers to abuse are ripe right now. And folks, it's happening. If you're in a situation where there's any imbalance in power, you need really good professional help with you to compromise, or you don't do it at all. If it's dangerous, you don't do it at all. You get yourself safe. Period. End of story. And by yourself, I mean yourself, your kids, your pets, for sure. Other things you can think about, there are some apps out there that help with negotiations, for example, on parenting time. Some of those are listed on our website. One that comes to mind is something called Our Family Wizard. These are technological apps that allow you to negotiate and document what's going on. Don't lose sight of other resources that are out there. Clergy, support groups. Talked about therapy. You can also go to groups where just being around other people who are going through what you're going through can be not only really helpful from a mental health, calming things down standpoint, but you're often going to hear some really good perspectives and ideas. So we strongly recommend those as well. Okay, with that being said, I'm going to pause and turn it over to my partner in crime, Izzy. Izzy, do we have any questions?
We do. We have quite a few, so we'll get right into it. Okay. This one is a little bit long, so bear with me. Okay, we are on our second PCDM since last July. The first one resigned mid-appointment. My soon-to-be ex is the one stonewalling, and I have been told by the professionals that they recognize this. At what point can a PCDM fine him or make him pay for his delay and avoidance strategies that drag the process along, costing me $350 an hour? When do I say this olive branch process is not getting my daughter a healthy co-parent environment?
Okay, thank you. So the question goes to a situation that's what we call post-decree. I presume that the folks are already divorced. They have one of these experts involved that are referred to in one of the early slides, a PCDM. This is an individual who is contracted to help decide disputes. Now, the good news is that where people are able to listen on both sides, it can be very helpful in moving things forward. The bad news is in a situation like the questioner's situation, the PCDM typically charges by the hour, and they're not inexpensive. And if you have somebody that is just playing games or not being cooperative, it can turn a bad situation even worse. So what do you do? And how do you perhaps consider getting out from under this supervision? I don't have a great answer for that, unfortunately. I would look to the terms of the agreement. A PCDM can only be in place and approved by a judge if both parties agree. Hopefully, the appointment of this kind of expert is time limited, so it's only for a specific period of time. And hopefully in the agreement, there are mechanisms in dealing with problems, including potentially ordering one side to pay fees. That's not always the case. Not everybody can agree to that level of specificity in the agreement, but you're going to need to look to the terms of that agreement to figure out what your options might be. But I feel for you. That's a tough, tough situation.
Thank you. Okay. And related, we have another question. What is a PCDM?
Okay, good question. I sometimes use these abbreviations too quickly. My apologies. PCDM, Parenting Coordinator / Decision Maker. In a nutshell, this is a person who is on the case, usually an attorney, who can act like a judge. It's basically a private judge. And the only way under our statutes and in general, this is the law of arbitration, to get a private judge, you're essentially taking things out of the hands of our public judges. You're giving the power to a third party. The only way that can happen is if both sides voluntarily agree. So PCDM is somebody who is agreed upon, then approved by a judge, usually after a divorce is complete, where there's high conflict, and both sides think and hope that it's best to have somebody who can be more sort of on call to resolve disputes as they come up.
Okay, thank you. Related to that,
No problem.
how do we prove parental alienation? Each time there's an issue, I write about it in our family wizard. However, when the issue is brought up by the PCDM or to the PCDM, he says, prove it.
So the question goes to alienation and how does one prove it? It's a very good question. And the dilemma that the questioner is facing comes from the controversy around this whole thing, parental alienation. The mental health folks have been debating for decades about whether or not this is real. And if it's real, whether or not it is a specific syndrome under the manuals or guides that govern the world of psychology. Okay, there's a big book. It's called the DSM, Diagnostic I'm messing that up, but it's sort of their listing of all the approved, accepted psychological syndromes that are out there. Alienation has come and gone as to whether it is an official syndrome. Currently, it is not listed in the DSM officially. There are things related to it that are in it. And regardless, I can tell you from my experience as an attorney, and most judges will tell you that parental alienation is a thing. And it is happening, and it's harmful, and it's terrible. And most good mental health experts will say that whether it's officially listed as a syndrome or not, we know that the kind of conduct that is inherent in alienation is harmful to kids, and we don't want it. The long story, however, is that with all this controversy comes a lack of consensus on how you prove it, what kind of evidence you need. The fact that you're documenting it is a really good thing. If you can have other witnesses that can confirm what you're saying, that's important, because these cases turn on credibility, who's telling the truth, who is not. Does your evidence include, gosh forbid, any mental health fallout amongst the kids? Can a therapist attest to it, in other words? So forgive me for the long answer, but you can tell that this is a difficult problem. And the key in quote unquote proving it is going to be getting some other evidence to back up your side of the story. And then if all else fails, finding a DM who understands this well enough that it's willing to investigate further. With that being said, I see we're out of time. My apologies.